While I've been studying candidates' backgrounds and writings, I've made no decision except one. The person I will nominate will be someone with extraordinary qualifications, character, experience, and integrity. And that person will be the first Black woman ever nominated to the United States Supreme Court.
President Biden renews his campaign promise to nominate a Black woman to the U.S. Supreme Court for the first time in the country's history, after 83-year-old Justice Stephen Breyer's announcement that he will retire. Hello, I'm Ghida Fakhry. Welcome to the program. U.S. Supreme Court justices are appointed for life, but occasionally they decide to step down. Last week, Justice Stephen Breyer announced his retirement after 28 years on the bench, giving a Democratic president the first opportunity to appoint a judge to the court since 2016, when President Barack Obama's attempt to fill a vacancy left by the passing of Justice Antonin Scalia was blocked by Republicans. That vacancy was eventually filled a year later by Donald Trump, a process that was marred by lingering partisan rancor over Supreme Court appointments, and that has weakened the apolitical standing of the court. The nomination of Supreme Court justices in recent years has become openly partisan. While the nation's highest court is meant to be above the fray, justices tend to reflect the position of U.S. elites and increasingly opine along party lines. Conflicts of interest are rife, and justices do not always recuse themselves from cases where they might have a personal interest. All of that has affected the public's confidence in the independence of the Supreme Court. According to a major poll taken late last year, only 40% of Americans said they approve of the job the court was doing. Now, over the course of U.S. history, the Supreme Court has issued controversial rulings, certainly by today's norms. It has ruled in support of forced sterilization of citizens believed to be mentally inferior, promoted racial segregation, and prevented African Americans from holding U.S. citizenship. Now, more recently, the court has allowed corporations to spend unlimited amounts of money on U.S. political campaigns. It is widely believed to have handed the presidency to George W. Bush through its 5-4 ruling in Bush v. Gore that stopped a recount of votes in Florida in the 2000 presidential election. Justice Sandra Day O'Connor, who voted with the Republican-appointed conservative majority, has since publicly called that ruling, quote, a mistake. Our first guest is former U.S. Senator Joe Lieberman, who would have been vice president in a Gore presidency. Senator Lieberman, you were the Democratic nominee for vice president in the 2000 U.S. elections. That election, of course, came down to a U.S. Supreme Court decision that essentially reversed a Florida Supreme Court's recount order, effectively handing Bush victory. You and Al Gore had won over 500,000 votes. That is the popular vote, which doesn't count in U.S. politics. At the end of the day, we all know that the outcome hinges on the Electoral College vote and those precious 25 Electoral College votes that came out of Florida. Looking back, though, how do you view the decision by the Supreme Court in 2000? Did it set a dangerous precedent that could have been used in 2020?
Yeah, well, first, good to be with you, Ghida, and thanks for a very interesting question. So I would say that when the decision of the Supreme Court of the United States was made in the 2000 election, Bush v. Gore case, it was so devoid of real precedent. In other words, in America, the courts up to the Supreme Court normally decide cases based on precedent, so they're not just picking judgments out of the air for personal reasons. And it seemed to be totally without reasonable precedent, without precedent, really. And therefore, we didn't think that it would have much weight in the years to follow. And it didn't. It's occasionally been cited in very strange and unpredictable ways. But it's not a leading case of the Supreme Court, which, at the time, we were very concerned that there was somehow a political element to the decision. But the Supreme Court of the United States is the final arbiter of the law in this rule of law country. And
wasn't there a political element, Senator? Because I know that you wanted to take this further at the time, you argued as a young lawyer that you should file lawsuits, that you shouldn't simply accept the Supreme Court's decision. You were talked out of it. Do you regret today not having taken it further? Was it a mistake?
No, I tell you, I'll give you the circumstances. I mean, right after the election, when it was clear there was going to be a long count, we met Vice President Gore, all the advisors, the lawyers, and I was really a hawk arguing based on my experience as the Attorney General of Connecticut during the 1980s, that if you think you've got a plausible case, take it to court. And if it's not convincing, the judge will rule against you. But don't give it up before you go to court. After the Supreme Court decided, Ghida, on that night, Al Gore called me late at night and 10:30, 11, and told me that we had lost in the Supreme Court and wanted me to know that some of our lawyers thought there was a basis in the Supreme Court decision for going back to the Florida course and asking for a full state recount. What did I think? And I said, I haven't seen the decision, but my instinct is there's so much on the line. It's worth going back to the Florida Supreme Court. So Al Gore said he would think about it, call me back probably 12:30 and said, I've thought about it and I made a decision that I don't like and you're not going to like, but I think it's in the best interest of the country. This has got to end because we're coming close to the time when a new administration has to take office. And we will, by appealing back to the Florida Supreme Court, really disturb the orderly process of transferring power in the American democracy. Well, the truth is, over the years, as I thought about it, he was right. It had to end, but it was painful, and it does make a point.
It was painful, and when you consider that it was only 537 votes that made the difference.
537 votes as compared to, as you said, 544,000 votes, which is the number of votes more that we got than the Bush-Cheney ticket got in the country.
Almost 500,000 in the popular vote. One of the justices, Republican appointed, Sandra Day O'Connor, called it a mistake in recent years. Do you think it was a mistake for the Supreme Court to have ruled the way it did?
I do. I will tell you, at the time when the Supreme Court took the case after the Florida State Supreme Court ruled in our favor, I was shocked. I thought there was no basis for it. And then I was doubly shocked and wounded, really, when the Supreme Court of the United States ruled in favor of Bush-Cheney. But that's the way it was. And again, I want to make the point. This is a rule of law country. And even if you don't agree with the judgment of the highest court in the land, you can't contest it. You can't because you ruin the system. Unfortunately, that's what we saw happen after the election and the court cases of 2020.
But what it did back in 2000 is it deepened the ideological divide on the court, with the 5 conservative Republican-appointed justices backing Bush and the 4 liberal Democrat-appointed justices backing Gore. The retiring Justice Breyer said in a speech at Harvard last spring, quote, "The court's decision in the 2000 presidential election, Bush v. Gore, is often referred to as an example of its favoritism of conservative causes. Has the court ever recovered from this intervention in the political process? Can it ever shake off this perceived bias?"
Yeah, it can from decision to decision. And of course, future justices write the rules and make the impression of the Supreme Court. But it was very troubling in that fundamentally troubling decision of the Supreme Court in the 2000 election that the break on the court was between the conservatives voting for Bush and the liberals voting for Gore and me and against Bush. And the troubling point was that really made it look political. We'll never know what it was. Justice Stevens, who was actually a Republican, appointed, I believe, by Republican President Ford, said in his dissenting opinion, because by then he was thought to be a liberal, and he said something like, we may never know who won the election of 2000, but we can say after this decision that the United States Supreme Court lost. In other words, it lost its credibility. There have been a lot of other cases since then, where some of the Republican-appointed conservative justices surprised people, such as Chief Justice Roberts voting twice to uphold Obamacare, and the Supreme Court in that case with Justice Brennan voting to essentially rule that laws invalidating gay marriage were unconstitutional. So there have been times since 2000 where the court has proven it's not totally predictable and on party lines or ideological lines, and those are the best times.
You mentioned Chief Justice Roberts, and he was one of 3 current justices who worked for Republicans and close to the Bush campaign back in 2000 in the ballot recount, legal battles that happened in Florida. So this idea of the Supreme Court being able to live up to its ideal of judicial independence and impartiality, does it really ever exist when, let's face it, you have 9 justices, 9 human beings, all with their own individual biases?
Yeah, and listen, I'll go back to the Constitution and the people who wrote the Constitution. Remember, we had 3 branches of government: Congress, the legislative, the executive branch, president, and then the Supreme Court. And the Supreme Court, in their formulation of the founders of America, was supposed to be the absolutely non-political branch of government. It was supposed to be up high, applying the law, the Constitution, without regard to partisanship or politics, and that would be the ultimate guarantor of the fairness of our government. But justices are people, and people don't always live up to the ideal. And in my opinion, they certainly didn't in the Bush v. Gore decision of 2000.
The Supreme Court rejected attempts by former President Trump to block the release of some 700 White House documents relating to the January 6th insurrection at the Capitol. It was an 8-1 decision. The only one who voted against was Justice Clarence Thomas, whose wife is a vocal supporter of the former president and quite an outspoken activist. President Trump undoubtedly will view this decision as a betrayal by the court's conservative majority. But how significant is this latest Supreme Court ruling?
Well, it's very significant, both in terms of the actual decision, but the larger point that it makes. It doesn't matter who nominates or appoints them, even though they're humans, and they would naturally be grateful to that president. But really, their responsibility is to a much higher authority than the president who appointed them. It's to the Constitution, and to apply the Constitution and the laws. They see it impartially, and that's clearly what they did in that case. So I thought that was just as the Bush v. Gore decision in 2000 was really heartbreaking and disappointing and discouraging. That decision of the current Supreme Court was encouraging and suggests that the law still is king or queen in the United States.
Former Senator Joe Lieberman, a real pleasure to have you on the program. Thank you so much for making it.
Thank you, Ghida. I enjoyed the discussion. We'll do it again. Good luck to you.
So how can the issues with the court be addressed? The NGO Fix the Court has identified 6 areas where the court can be reformed: imposing term limits on justices, allowing broadcast media to cover court proceedings, imposing the same code of ethics that are followed by federal judges, barring justices from owning stocks, forcing them to provide financial disclosures, and allowing media coverage of any public appearances made by justices. But are any of these issues likely to change? My next guest is Leslie Proll, a civil rights attorney and advisor to the National Association for the Advancement of Colored People, the NAACP, on federal judicial nominations. Leslie Proll, President Biden has repeated his pledge that he wants to nominate the first Black woman to the Supreme Court. But is it enough to have a nominee who checks a few demographic boxes on race, on gender, when the fundamental structure and the real powers behind the institution, the Supreme Court, remain unchanged?
Well, this is a historic moment, certainly, with the nomination of the first Black woman. This is earth-breaking, ground-shattering, but it comes at a time that the court has been at its grimmest, really, in a lifetime. It is not just extreme. It is not just conservative. These 6 justices, 3 of whom were appointed by Donald Trump, are really examining long-standing precedents on reproductive choice, on affirmative action. So the legitimacy of the Supreme Court is at stake here.
You say legitimacy is important. Of course, diversity is also important. The court needs to reflect America's changing demographics. But in the end, will it be more about changing the optics than about real, genuine change? Because look at the makeup and the culture of the current court. There are more former corporate lawyers than there are public defenders, civil rights defenders.
You know, it's not just the demographics of the nominee, it's the type of nominee that we hope this will be. This is going to be somebody who has an expansive view of the Constitution, somebody who's not going to be willing to overturn precedent in order to please a certain political base. So you have to go behind this historic moment of nominating the first Black woman, but also who this will be. What voice will she have on the court?
The retiring justice has repeatedly warned that political machinations could be the ruin of the institution. In his words, he says, a judge's loyalty is to the rule of law, not the political party that helped to secure his or her appointment. But when you look at his politically timed exit, that was designed to help the party that nominated him. Is there any doubt that it is the party that calls the shot at the end of the day, not the justice himself?
I'm not going to question Justice Breyer's motives for leaving the court. I will say that the last 3 nominations to the court have been so incredibly unfair and politicized in terms of the way that the Senate refused to consider President Obama's nominee and then went forward and put President Trump's on, and then certainly confirming Justice Amy Coney Barrett right before the presidential election. So there is a lot of context, I'm sure, in which Justice Breyer was making his decision, and now we have it, and now we're looking forward to having the Senate confirm his successor.
And just finally, how much of a battle are we going to see? Because it does put the Republicans on the spot. What will their strategy be with this nomination, especially after America's recent reckoning with race and racial justice?
I would like to think that they would be supportive of an incredibly qualified Black woman, the first to the Supreme Court, but they have disappointed us many times in terms of their ability to appreciate diversity and representation. And so I am, hoping for the best, but expecting and preparing for the worst.
All right, a wise position to have. Leslie Proll, thank you so much for joining me.
Thank you.
Now, as we mentioned, although Biden promised during the campaign that he would appoint a Black woman to the court, there is already pushback from some members of his own party. Several Republican lawmakers have publicly criticized the president's pledge, which they say puts race and gender above qualifications. April Rain is an attorney and activist who started the Oscars So White movement that led to an effort to diversify the Academy of Motion Pictures. She's now leading a campaign to make sure the first Black woman is appointed to the U.S. Supreme Court. April Rain, you and other Black women activists have been mobilizing to make sure that this historic opportunity becomes reality, that Biden lives up to his promise, that he keeps it, although it's not all entirely up to him, because members of the Supreme Court are nominated by the president with the Senate's approval. How much of a fight will the president have on his hands to make sure that his pledge happens? How far will he go to keep his word?
Well, I believe that President Biden is going to go all the way because he keeps his promises. And as he promised during the campaign, he would nominate a Black woman to the Supreme Court. What we know is that the United States Senate, as you mentioned, is the body that will confirm President Biden's nominee, and they are currently at 50-50, 50 Democrats and 50 Republicans. So there may be a bit of a struggle within the Senate, but what we know is that President Biden's nominee is going to be eminently qualified, and so hopefully there will be not as much struggle as people would anticipate.
You say she, if it is a Black woman, as he said it will be eminently qualified. And there hasn't been a shortage of qualified Black women in the past. But the Supreme Court has had, in its entire history, 115 justices. 108 of them have been white men. For 2 centuries, the only people considered were white men. Why hasn't the U.S. ever had a Black woman in the nation's highest court?
It's an excellent question, and it's not clear. The United States federal courts play a massive role in maintaining and expanding civil and human rights in this country. Seeing more Black women on these courts is critical to having representation that understands the unique needs of Black and Brown people. So my organization, She Will Rise, was formed to address the underrepresentation of Black women in the federal judiciary and the Supreme Court. Not one Black woman has been ever nominated to serve on the Supreme Court, as you mentioned, and this is a consequence of systemic inequality and an erosion of trust, especially felt amongst Black women who repeatedly turn out in record numbers to represent our communities through our vote.
And they are underrepresented in the legal business as well. Women of color often have to go above and beyond to prove their qualifications. And according to data from the American Bar Association, only 3% of sitting judges in the United States are Black women.
That's exactly right. What I will say is that President Biden has been very intentionally inclusive in his first year in office in increasing the number of Black women throughout the federal judiciary. So there are more now than there ever have been before. And in fact, on our website, sistascotus.org, we have a federal judiciary tracker. So you can see who's been confirmed, you can see who's been nominated. And in fact, some of those nominations have been stalled for months now.
How determined do you think are those who don't want to see a Black woman on the Supreme Court? President Obama had the chance to nominate a Black woman back in 2010 and in 2016. He didn't seize the opportunity. And today, some Republican members of Congress are saying that a Black woman would be, quote, a beneficiary of affirmative action. Others are calling Biden's pledge race-obsessed and gender-obsessed, saying he is putting those criteria of race and gender ahead of the person's qualifications.
Yeah, I think that's ironic because white women benefit the most from affirmative action in the United States. So when we look at the scores of Black women attorneys and judges who actually have more experience and are more qualified than someone like, for example, current Supreme Court Justice Amy Coney Barrett, it is surprising that we hear about affirmative action when we did not hear affirmative action when she was nominated. In fact, what we need to remember is that a Black woman coming to the court is going to provide legal acumen and her lived experience, which is going to be incredibly important in deliberation with her colleagues to foster a more complete awareness of the variety of litigants and communities future rulings may impact disproportionately.
You mentioned irony. A year ago, then candidate Biden made the pledge in South Carolina during a presidential debate. He needed Black women's votes, and he understood their power. They're also among the most, if not the most, loyal Democratic constituency. Is it a way for him to simply energize an important part of the Democratic base, the progressive base, ahead of the midterms? Is this about diversity or just political expediency?
Well, I believe it's all of the above. We know that the midterms are going to be difficult, as they always are, for sitting presidents. However, President Biden is going above and beyond and in being intentionally inclusive in his Supreme Court choices. But as you mentioned at the start, let's remember that this isn't all on President Biden. We have 1/3 of the Senate that is also up for election in the midterms. And so it's not just President Biden's legacy that we are looking at, it's also the legacy of the Senate. But to be very clear, this particular nominee is going to impact all Americans, not just Black women, not just Black and Brown people in the United States, but the entire country.
April Reign, thank you so much for joining us.
Thank you.
Now, here in the United States, it is widely accepted that one of the most important and consequential decisions a president can take isn't about wars. In theory, that is the exclusive purview of Congress, but to nominate Supreme Court justices, and for good reason. Historically, justices have, on average, spent 16 years on the court. Since 1970, the average tenure has been 27 years. With increasing life expectancy and the appointment of justices in their late 40s, early 50s, they can expect to sit on the bench of the highest court in the land for 30 or even 40 years. The political impact of any nomination could outlive a presidency by decades. Now, politics has always hovered over the Supreme Court, but since the 2005 4 ruling that effectively handed over the presidency to George W. Bush, the court has been part of the political fray. The partisan acrimony surrounding hearings of nominees illustrates this, and many of the court's rulings have demonstrated it. And that is having a pernicious effect on American democracy and the court's public standing. And so, in short, the current opening on the court offers President Biden an opportunity to appoint a younger, liberal justice, whilst Democrats still control the Senate. The days when Supreme Court nominees could hope for a bipartisan Senate confirmation are bygone. For now, the ideological imbalance on the court remains the same: 6 Republicans and 3 Democrats, not to mention the ethnic imbalance. The added risk for Democrats and democracy is that the composition of the court could tilt even more to the right if Democrats don't hold on to power long enough. That's all from me, Ghida, Fakhry, and the team. Thanks for watching.